Welcome to Legal Aspects of EMS. We started off talking about some terms. These are terms that you will need to know for your exam. Start off with assault and battery. Assault, not a pepper, assault. Assault is threatening, attempting, or causing a fear of offensive physical contact with a patient or other individual. Battery is unlawful touching of another person without consent. So, for example, if a patient said, I'm going to come over there and kick the snot out of you, that would be assault. Now, if the patient came over there and began to kick and punch you repeatedly, that would be battery. Abandonment. Terminating patient care without making sure that care will continue at the same level or higher. This means that if you went to a scene and you evaluated a patient and you left, if you didn't do, or if the patient wanted to go but you did not take them for whatever reason, then that could be classified as abandonment. Negligence is a deviation from the accepted standard of care resulting in further injury to the patient. 4 elements must be present to prove negligence. There must have been a duty to act. The healthcare professional breached that duty. Injury and/or damages, physical or psychological, must have been inflicted, and the actions of the healthcare professional caused the injury or damage. Proximate cause. What this means is, for example, you went and picked up a patient out of a motor vehicle collision, and instead of properly immobilizing them, you decided to walk them out of the vehicle and into your ambulance. If that patient suffered a cervical vertebrae fracture of any kind or any other vertebrae fracture of any kind, then you would be found to be negligent. And that is because you responded to that scene, so there was a duty to act. You breached that duty by not performing those standards, by not utilizing proper mobilization techniques. And an injury occurred, which is the fractured vertebrae, which is a piece of your spine, and the action of you not performing that duty caused that injury. Duty to act may be a formal contractual duty or an implied duty. A legal duty to act may not exist, but a moral or ethical duty to act may exist, and this is something that you may need to deal with. For example, in Kentucky, you are not required to stop and assist a patient if you are off duty. You may feel a moral or ethical compulsion to stop, and that is between you, your morals and ethics, and your employer. Some employers will allow you to operate under the auspices of the medical director you work for. Some may not. However, when we are talking about a formal contractual duty to act, this is particularly when you are on shift. For example, if it is 6:58 and a run comes in and you get off shift at 7, if you choose not to go on that run and there is no crew there to relieve you, you are breaching that duty to act because you are formally contracted to respond to that run because that is within your shift. Breach of duty is performing skills or treatments outside your scope of care can lead to a breach of duty. Breach of duty may be proved if you fail to act or you act inappropriately. For example, if you attempted to start an IV and a patient developed phlebitis, Well, IVs are outside of the scope of practice for an EMT. Damages. Damages occur if the patient is injured either physically or psychologically by your breach of duty. For example, the phlebitis, which is inflammation of the veins, came from your IV access, which was outside of your scope. So you breached that duty and you caused damages. Proximate cause. Proximate cause is established when your action or inaction was the cause of or contributed to the patient's injury. You could reasonably foresee that your action or inaction would result in that damage. If we go back to the car accident analogy where you walked a patient out of a car accident to your stretcher. While no, you did not cause that vertebrae to fracture, you did not prevent further damage by performing appropriate immobilization. Therefore, you contributed to that patient's injury. And this is something that you could reasonably foresee that your action or inaction would result in. Protecting against negligence claims. Maintain a professional attitude and conduct. Provide skills and treatment within your scope of care. Maintain mastery of your skills. Participate in CE and refresher programs. Follow instructions provided by medical oversight authority. Follow standing orders or protocols. Provide patients with a consistently high standard of care. And make sure your documentation is thorough and accurate. Some things you'll hear us, me or several of your instructors say is if you did not write it down, it did not happen. So it is imperative to make sure your documentation is impeccable. And a professional attitude will go a long way, whether you're on the stand or whether you're dealing with your patient or for whatever reason. Professional attitude will go a long way. And a thorough knowledge of your profession will be to your benefit. If you are forced to go onto the stand, one of the things that the prosecuting attorney may attack is, by attacking your credibility, is attacking your knowledge. They may want to see if you know the things that a standard EMT would know.